Hey guys, welcome to this video. We're going to talk about a very recent case. Actually came out yesterday, April the 9th, from the Second Circuit Court of Appeals. And this is a Fair Credit Reporting Act case, and it has to do with public records. And I really want you to see this because it has a lot of application to something that I get asked probably once or twice a week, which is, hey, I have a bankruptcy. I froze my LexisNexis account, but Equifax, Experian, TransUnion, whoever, they say they are verifying the bankruptcy either with LexisNexis or with the bankruptcy court. Can I sue them for that? And my question is always, is the information about the bankruptcy correct or incorrect? And they go, no, that doesn't matter. They're lying to me about how they're confirming it, or I froze it with LexisNexis, so it doesn't matter whether it's right or wrong. And I say, well, actually it does. So I want you to see this case. And this is Jacob Shimon, I guess is how you say it, against Equifax. This will be a little summary here. So in March 2013, there was a, let's call it $22,000 default judgment against him. And then he later appears in the case and they end up resolving the case. So there's a stipulation of settlement. And then he starts disputing to Equifax saying, hey, you're reporting this judgment. Now back at this time, the bureaus reported judgments. They don't anymore, not Equifax, Experian, TransUnion. And Equifax updated it to say it was satisfied, and he didn't like that. So he said that that was willful and negligent violation, and you also didn't give me the right information about the source and some other things. And the district judge said, hey, the report was accurate and you have no damages. And then Equifax doesn't have to prove that this was a reasonable interpretation of the law, which can insulate them or protect them from punitive damages. So let's look at the actual opinion. So it's really three sections: the source disclosure, accurate reporting, and reinvestigation. And so you see these listed here: 1681G, 1681EB, that's the reasonable procedures to have maximum possible accuracy. 1681I, which broadly speaking, that's talking about investigation. When you go to a bureau and say there is an error, what do they have to do in investigating? What do they have to tell you about the source of information? And the appellate court says the district court correctly determined that the report was accurate and you have no damages. And so that's really the end of the case. So again, a little bit of background: sued in 2012. There's a default judgment. The default judgment being I was served and I did not answer. And then he comes in and says, hey, I want this judgment set aside and I'm bringing counterclaims. And what they did is the parties, this is the one that sued and then the consumer, agreed that the stipulation would be that this resolves the action, discontinues all claims with prejudice. Problem is the court just noted that it was settled. That's all the court said. And so in 2014, he looks at his credit report and he sees this judgment. And so he says, hey, that's not accurate because the judgment's been dismissed after trial. Now think about that. Was that correct? Was it dismissed after trial? No, it just says settled. Doesn't say anything about a trial. Doesn't say it's dismissed. Just says it's settled. So he says, I want this removed. I want you to correct the information. So what Equifax does is they change it to say judgment satisfied. And all we know is sometime in 2016, it says he contacts Equifax repeatedly by phone, disputing the accuracy of the judgment satisfied and asking Equifax, how'd you verify this statement? And Equifax says, well, we contacted Kings County Civil Court and they said it's accurate. And so he files a class action lawsuit and says, you violated the Fair Credit Reporting Act. Then the judge throws it out. So let's go down here and see, well, why do we have the FCRA? Enacted in 1970 about the accuracy and privacy issues. And if a reporting agency, that's like Equifax, willfully fails to comply with any requirement of the FCRA, it may be held liable for actual damages as well as potentially for punitive damage. Now, we generally call this statutory damages. This, at least 100, not more than 1,000. And punitive damages. And if they negligently violate, so negligence is here, willfulness is up here. then you can get actual damages. So the court's going to break these claims up. And here's the reporting claim. So the consumer says reporting it as satisfied is not correct. And so you owe me under section 1681EB. That's maximum possible accuracy. And so here's the standard that the Second Circuit is using for whether something is accurate or inaccurate. It's inaccurate either because it's patently incorrect or when it's misleading in such a way and to such an extent it can be expected to have an adverse effect. So notice this expected to have an adverse effect is not when it's just flat out wrong. Okay, this is just when, well, it's not flat out wrong, but it's kind of misleading, a little bit deceptive. So here's the Fourth Circuit. Report is inaccurate when it is either just obviously incorrect or when it is misleading in such a way and to such an extent we expect to have an adverse effect. And the district judge, a trial judge, says marking the judgment as satisfied is accurate, and the Second Circuit Court of Appeals agrees. And so the consumer acknowledges that the court reported that the case against him was settled. And he also doesn't argue with the standard practice is reporting a settled debt collection judgment as satisfied. And he says, no, this stipulation, there's an implicit vacation or removal or setting aside of the judgment. And so he says you're obligated to report the judgment as vacated. And they just point out the state court docket does not reflect that. So you lose. Okay. And I'm going to tie all this in with the bankruptcy when we finish. So then he says, well, it misled the readers. Maybe it's not just flatly incorrect, but it misleads people because it implies a judgment remains. And they say, no, actually describing a judgment as satisfied means the opposite. It's discharge. You've met your financial obligation. And so they say that's fatal to your section 1681EB. Again, reasonable procedures in place to assure maximum possible accuracy. So you have to have an inaccuracy to bring a claim under EB. And so they throw that out. Now there's a footnote. I do want to drop down and see this. He also has a claim, maybe, that there was a lousy investigation done. And they say, well, you didn't really raise that, but because the district court correctly concluded the credit report was accurate, you lose. Okay? So again, you have to have an inaccuracy to be able to bring a claim under section I. Just remember, I is for investigation, or EB, which is reasonable procedures to assure maximum possible accuracy. All right, so let's go back. So we've settled the issue, at least the court has, that this reporting was correct. Now, what about not telling me the source and not giving me some information about the reinvestigation, and specifically on negligence? Okay. So here's 1681GA. Every consumer reporting agency shall, upon request, clearly and accurately disclose to the consumer the sources of information. And then here's the I claim. We'll just call it Equifax must provide notification of dispute to any person who provided the item, promptly provide to the person who provided the information and dispute all relevant information about the dispute. And then this is really the part. After receiving a request from the consumer, provide the consumer within 15 days a description of the procedure used to determine the accuracy and completeness of the information, including the name and address. Okay. But the court goes, here's the problem. For negligence, you have to have actual damages. Okay. So a plaintiff bears a burden proving actual damages. In the absence of such proof of actual damages, the claim cannot survive summary judgment. So the negligence claims under section G and I require that you suffer actual damages when Equifax failed to disclose and to treat LexisNexis as the source and furnisher. And the court says, well, even if Equifax should have disclosed LexisNexis, and the court's not saying that that's true, but just even if it was true, there's no evidence you suffered any damage. Okay? And they say, we agree that you suffered no damage. Since the characterization provided by Equifax in its credit report was accurate, remember that's the first section we looked at, for the consumer to have learned LexisNexis was an intermediary source would not have enabled the consumer to avoid the emotional damage he claims to have suffered as a result that the report was marked as satisfied. The debt was marked as satisfied. And so no damages arising from the failure to treat LexisNexis as a source or a furnisher. And so you lose the negligence claims. But there's still the willful claims. And that can be the statutory damages, 100 to 1,000, or punitive damages. You can get either or both if you have willfulness. So they go to the Safeco decision back about 14 years ago, the U.S. Supreme Court. There the court explained a company does not act in reckless disregard, when reckless disregard is the same thing as willful. Okay? However, if its reading of the statute was not objectively unreasonable, so let's sort of flip that around. If it's objectively reasonable, may not be correct, but if it's objectively reasonable, then the U.S. Supreme Court says you can't get punitive damages under the FCRA. Okay. And so the district court dismissed the G claim, okay, after concluding Equifax reasonably interpreted source not to include a contractor intermediary. In other words, you have over here is the court, over here is Equifax. Well, Equifax didn't go to the court. They hired LexisNexis to go to the court. Could have been Joe Blow or Susie Smith or Jamal Murray or whoever it is, okay? And this intermediate person, the court's saying, well, you know, it's reasonable to say you don't have to list somebody that is working for you, okay? And so the FCRA's reinvestigation provision requires under certain circumstances provide information about any furnisher, provide notice. Okay, so now let's go back to that source disclosure. Equifax argues it's a reasonable construction to understand sources of information to refer to the original source, not the identity of contractors. And the court says we agree that these are reasonable interpretations. Not saying they agree this is the actual truth, but saying this was a reasonable argument that you can make. So it is an objectively reasonable reading to exclude from furnisher and sources a contractor such as LexisNexis when working on the reporting agency's behalf. And they identified the court as the furnisher or the source, and that undisclosed contractor, because the consumer wasn't told about LexisNexis. That undisclosed contractor, its job was to check the files in the court and see if the report is accurate. Now the consumer says, well, that's not good enough. Here's my counter argument, my parry here, is that you're entitled to that defense only if you can show that you actually interpreted it that way before deciding not to disclose. And they say, we reject that. And the Supreme Court said whether a company committed a willful violation must be an objective inquiry, dismissed arguments that evidence of subjective bad faith could create liability. And then they say whatever their subjective intent, like whether they thought this or didn't think it, it just doesn't matter. And they say, you know, we conclude Equifax does not need to prove it actually adopted the interpretations we conclude were not objectively unreasonable. Okay. And then in the conclusion, they kind of, I think, take a little bit of shot at the consumer. So you chose to expend considerable time and energy contesting an accurate credit report. When Equifax advised its customers the judgment against you was satisfied, it gave an accurate report. And they accurately obtained the information from the King County Civil Court. We don't decide today, so they're leaving this issue open, whether they should have told you about LexisNexis. And they say there's two reasons for that. Number one, because these statutes, 1681G, 1681I, can be reasonably interpreted not to require such disclosure. Number two, even if they were negligent, you have no harm, so you lose. So why do I share this case with you? Well, first of all, it's the most recent appellate court case on the FCRA, so it has value. But here's the scenario. People, again, come to me and say, I've got this bankruptcy, and I suppressed or I froze my LexisNexis account, and I disputed it with Equifax, Experian, TransUnion, and they say they verified it with the court. So I go to the court, and I get a letter saying, we don't verify anything to credit bureaus. So see, they're lying to me. And I go, well, is what happened in the court actually what's showing up on your credit report? They go, well, that doesn't matter. See, they lied about going to the court to verify it. They really use LexisNexis. And they can't use LexisNexis because I froze my LexisNexis report. Here's the problem with that. This court's saying, at least they think it's a reasonable interpretation for punitive damages purposes, that they can say we got it from the court, even though they didn't literally get it from the court. They had this intermediate go to the court. But the other thing in this bankruptcy context is there's a misunderstanding about your LexisNexis credit report, which there is a credit report, and LexisNexis serving as a contractor or an agent for one of the bureaus to go get public records. See, Equifax could hire me or you or your neighbor or the teacher at your kid's school to go sit at the courthouse and pull records. Well, now, it's obviously done by computer. So you may freeze the LexisNexis report and, it doesn't really do anything, but, you can do that. But that doesn't stop LexisNexis from being hired by the bureaus to go look in the PACER system. That's where bankruptcies are kept. So I just want you to see this. And look, if you do all these sort of, get the letter from the clerk's office and freeze LexisNexis and you dispute it and it comes off, and that's what you want, that's great. Now, I will say this, if you're buying a house, they're going to know that you had a bankruptcy because they don't just look at your credit report. They just do a PACER search and they'll find it. But understand, just because it may come off doesn't mean that you can sue if it does not come off. Okay, there's a difference in credit repair, and maybe I can get something off my credit report versus, hey, the bureau won't fix this true legitimate error, and now I get to sue them. I can't sue the credit bureau if they're accurately reporting your bankruptcy case, and we just don't like the way that they worded about where did they verify it or who did they get the information from. If it's accurate, that's pretty much going to gut your case, okay? So you need to instead of spending all this time like getting a letter from the clerk's office and all, just find the inaccuracies in that bankruptcy report. So you know what the court says, you know what your credit report. If this says you filed the case in February 2019 and this says March 2019, guess what? That's inaccurate. It's obviously inaccurate. We don't have to get into whether it's misleading or not. It's just wrong. This says February, this says March. If it says, let's say you filed a Chapter 7 and this says it's Chapter 13, that's wrong. This has the wrong case number, that's wrong. This has the wrong date of discharge, that's wrong. You can dispute that. So I'd much rather see people spend time on that rather than doing all this sort of gymnastics that, occasionally works, but it's sort of like saying, well, I sent my dispute letters in on pink paper and it worked. Therefore, pink paper, no. Some disputes are always going to work at some point, okay? So you're going to get it off your credit report, whether you freeze your LexisNexis, whether you get the letter from the clerk's office, you're either going to get it off or not, okay? Like I said, I would rather do a dispute where either they fix it or they delete it, or then I have the ability to sue. And that's the way that we do things. That's the way that we teach consumers how to do this. Dispute so that it gets fixed, delete it, or you can file a lawsuit. Because when you file the lawsuit, then they delete it and then they pay you money. And so that's a great solution. Okay, so I hope that you enjoyed this. Let me get back to the screen just so you can see the exact name of the case. So decided April 9, 2021, Jacob Shimon versus Equifax. And this is in the Court of Appeals for Second Circuit. Okay, guys, have a good one. Bye-bye.